Commissioner Duran.
Here.
Commissioner Foster.
Here.
Commissioner Sultan. Here. And Commissioner Trosas.
Here.
And Commissioner Phyllis is not here yet.
Great. So please now join me in a salute to our flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, just before we get started, I think all of you have been here before, but in case anyone wishes to address the board on a specific item on tonight's agenda or for public comment, please approach Mr. Gwynn and fill out a speaker slip. Thanks. Is there a motion on the floor here to approve the minutes from last meeting?
I would so move to approve the minutes from last meeting from those of us who were present.
And I will second.
Can we voice vote? All those in favor say aye.
Aye.
Aye. Any opposed? Nope. Okay. Great. The minutes are approved. Moving now on to special agenda items, brief announcements from Ms. Condon.
Yes, good evening. Just a couple of announcements tonight. Just a reminder that this is Fair Housing Month, and on April 23rd there will be a Fair Housing Workshop. I think the attendance, it may already be booked full, but anybody who's interested in attending can put their name on the wait list, and usually those people are able to get in. So it's April 23rd from 9 to noon at the main library multi-purpose room, and there will be special panels on the issues of gentrification, disability, and the Section 8 program. And then there's another event related to Fair Housing Month, and that's the posters that the local school children create. And this coming Monday, those will be displayed in the City Hall lobby. And everybody has an opportunity to vote for their favorite one, and that will be the People's Choice winner. And that will be this Monday. You can vote between 9 and noon or 3 to 5. So everybody's invited to participate. And then our next rent control seminar will be Wednesday, May 8th. It's the tenant seminar, but everybody's welcome. That will also be at the main library multi-purpose room from 9:30 till noon. And anybody interested in signing up should either call the rent control office or sign up through our website by sending an email. And that's what I have this evening. Thank you.
Thank you. Am I allowed to make a special announcement? I just wanted to let everyone know that yesterday was the 40th anniversary of rent control in Santa Monica. So thank you to all who celebrated, and thank you to the great work that you do upholding rent control. 40 years, I think that's a big accomplishment. So I just wanted to say that. Okay, public comment. So again, this is a time set aside for members of the public to address the board on items not on tonight's agenda. I believe that we have one public comment. Michael Millman, you are allowed 3 minutes.
Well, good evening. Michael Millman, M-I-L-L-M-A-N. Good evening to everyone. 3 items to talk about that are not otherwise agendized on our program. Congratulations to my rent-burdened friends and tenants along Ocean Avenue with the commanding view of the Pacific Ocean. I'm proud to announce that our investigation indicates that their rental adjustment this year will be approximately 2%. So I'm so happy for them. Number 2, I don't know if it's possible to address the chair and the rent control agency as a paying member, because my family does pay registration fees. I would like to get and then make an application to receive it, if it's not a hardship or a problem, an updated listing of those bills in Sacramento from Brian Augusto. When he was here last, he only had a small portion of the bills, and effective on February 15th of this year, all the bills came through. And I'm sure from time to time, he is going to give you an updated listing of those bills and his comments. Again, my family paid. I think we're entitled to that list. But if the list costs extra money, please let me know and I'll pay. Finally, we're at Defcon 3. We are not getting any support from this board on earthquake retrofit. The people in the building department downstairs, at least I've heard from contractors, are insensitive, lack compassion, difficult, and rude. They have a bad temperament and a bad attitude. One guy that was going to do my building walked away, says, I'll do LA, Mr. Millman, on your buildings, but I won't do Santa Monica. So I think staff should look at them and have a nice heart-to-heart talk with our friends downstairs and say, we need help and cooperation. This has to be friendly. This is a lot of money. So we can't do it, the owners, but these owners are not getting the kind of help they need in terms of what's going on downstairs, okay? So I think staff should be tasked to that responsibility. While you're talking to them, to get this deal effective, you need one grade beam and one moment frame. Some of our friends, engineers, are over-engineering and it's just collapsing financially, these small mom and pops. So they need a little guidance. It's the same program in LA. You know, one moment frame, one grade beam. Finally, I'm advised that FEMA has money for this program. And you should look into it. Thank you.
Yeah, Mr. Millman, thank you very much. I think we are aware about FEMA, so thanks for bringing that to our attention again. I would just like to note on the listing of bills from Mr. Augusta, he actually has a weekly email list. We're not allowed to talk about that? Okay. All right. Never mind. I think it wouldn't be unreasonable to ask for the bills because actually I care about that. So anyways, go ahead.
Mr. Augusta will be joining us soon for a meeting, and he always prepares for that a list of all of the bills, and so that is always a public document. We will be happy to share that with Mr. Millman and the rest of the public as we do whenever he presents that report. I hope he might be able to come to the May meeting. I'm not sure if it will be May, but it will be relatively soon. So as soon as we have that report, it's a public document and will be available to Mr. Millman.
Thank you.
Okay. And then just really briefly on the interactions between building and safety, code enforcement in this body, hopefully you know that your requests are not falling on deaf ears. I think we've talked about this here multiple times, and I just wanted, I know I can't really address that, but I know we've sent guidance to City Council, explicitly asking for iterative.
Right.
I don't know if you can elaborate.
Well,
on that.
I have spoken with people in the Building and Safety Department recently, and I don't hear the reports that Mr. Millman tells us. There are people applying for these retrofitting permits. They are being issued. I don't know about dealing with the contractors. That's not our expertise, clearly. But I will check in with them again. I've asked them if they can give us sort of an update of how many buildings have submitted their engineering reports, how many buildings have pulled permits, and so I will get that information with them and share it with you and with others who are interested. Following, I believe it was the last meeting when Mr. Jay Johnson was here and talked about the potential of some money available from FEMA, we did write a letter supporting the city's application for those funds. They sent a preliminary request for those funds, but the application has not been filed yet. But we have sent our letter on behalf of the board and gave Mr. Johnson a copy of that. I'm happy to share that with Mr. Millman and anybody else as well. So we're following up on that.
Thank you, Miss. Okay, sorry. Yeah, thank you, Mr. Millman. Just on a slightly related but other note. I've asked for this several times, and I would like to again extend the invitation to our neighborhood preservation coordinator, as well as building and safety and code enforcement, to talk to us about how the agencies are working together. Maybe they can give us an update on how it's going with the earthquake retrofitting. I think in light of some of the articles in the Santa Monica Daily Press, et cetera, it might behoove all of us for them to set the record straight about how they're assisting rent-controlled tenants. So I would love our neighborhood preservation coordinator as well as those other two agencies to come back similar to a presentation that they did, I think, for us last year, because I would hope that we're seeing some better coordination between the agencies. So thanks.
Thank you.
Thank you. Okay, let's see. Moving on. If I had the agenda in front of me, that would be helpful. All right, so moving on to 10 jurisdictional items. 10A1, 2432 3rd Street, applicant P. Withers. Can we have a staff report, please?
Commissioners, Mr. Paul Withers has applied for his property in 2432 3rd Street, which he bought in 2007, and he states that he moved on to it in November of 2017. He applied for its exemption last year, but the board found that he had failed to provide sufficient evidence to show that he lived on the property for the required full 120 days before filing the application. Mr. Withers has now reapplied for the exemption, and he's provided new types of evidence to convince the board of his claimed occupancy. He took the step of wearing an ankle monitor and using a third-party monitoring company to provide a record of his whereabouts. Now, the monitoring GPS often shows him at a location at a neighboring address, and Mr. Withers says this is just a glitch with the GPS and that those instances are when he's at home. And taking that into account, that would show him sleeping at his property every day from July 28th through November 26th of 2018. He also submitted footage from various security cameras that he has on the property. He edited the footage to provide 2 or 3 minute video clips. The clips show him leaving and returning to the property for each day of the application period. Although Mr. Withers likely submitted these edited versions to avoid lengthy footage, the alteration may raise questions about the authenticity of the footage. However, the hearing officer noted that the video and the screenshots from the cameras match the evidence that's provided by the GPS location data and selfies. Mr. Withers submitted selfies that he took with his phone every day for the period that's at issue. The pictures all show him in front of the property. He stated that he altered the original image by using an app to mark those pictures with a time and date stamp. And doing so may raise issues about the authenticity of the photos, but the hearing officer again noted that the selfies and Mr. Withers' attire match the security camera videos and the GPS location data. Mr. Withers also submitted alarm logs from his house alarm. The alarm needs to be armed and disarmed manually, and Mr. Withers testified that he's the only person with that code. The alarm logs do not in and of themselves prove that Mr. Withers is the one arming and disarming them, but they are consistent again with the other evidence. Google timeline location data about the location of Mr. Withers' cell phone is consistent with this other evidence as well. Cell phone records show numerous calls originating in Santa Monica, which is consistent with the other evidence about his whereabouts. Low usage of utilities were a deciding factor in the board's previous denial of Mr. Withers' application. This time the usage is not negligible, but it is low compared to the usage of his tenants, who are the Ross family. The Rosses, however, are 2 adults and 2 children. Ms. Ross works from home. The family does numerous loads of laundry at home and use a regular water heater. Mr. Withers doesn't use the gas heater in his unit because of repair issues. He doesn't use the stove, he said, because he usually eats out or microwaves pre-cooked meals. And his water heater is an efficient tankless model. He also said that he rarely uses the clothes dryer. His mail, utility bills, driver license, registration, insurance information, and property tax bill all show the property as his address. Mr. Withers has a homeowner's exemption for the property. Voter and registration records show the property as his address. Mr. Ross, who is the tenant in Unit B, continued to insist at the hearing that Mr. Withers does not live on the property, and also that he had divided his unit in 2, making it a 4-unit property. But board records and RealQuest data both show the property as a 3-unit property. In the previous case, Mr. Ross said that Mr. Withers was using a portion of his unit for Airbnb and had a door separating the upper and lower levels of his unit. Having heard that, the hearing officer and the board found the property nonetheless to be a 3-unit property. Mr. Ross did not submit any new evidence to change that finding. In fact, Mr. Withers testified that he had stopped Airbnb-ing his unit as of September of last year and had removed the door that separated levels of his unit, which is corroborated by the testimony of his workman. Mr. Ross also conceded at the hearing that he had not seen any Airbnb guests since September of last year, consistent with Mr. Withers' testimony. Mr. Ross also testified that he saw Mr. Withers an average of twice a week since August of last year, and that his car was in the driveway nearly every day. He also said that he couldn't see the back entry to Mr. Withers' unit because contractors were usually in the driveway. Because the evidence in the record preponderates in favor of Mr. Withers' claimed residence since at least August 2018, staff recommends that the board grant the application.
Thank you very much. We will hear first from Paul Withers, who has requested 5 minutes.
First of all, I just want to say thank you to everybody. Your advice last year to come back and show more evidence. That was essentially just, what the issue was last year. It's hard. I had no idea how hard it is to prove that you do live somewhere, but it turns out it is hard when you've got people who want to fight it every step of the way. So I took your advice and I gathered more evidence. This right here is probably a quarter of what I brought to the hearing. But that's it. I've been living here, and as you can see from the evidence. I don't know what else to say, but I just, thanks for your advice. It was a hard thing to do, but I just set out on the task, and I'm hoping tonight that it pays off. I don't know what else to say, but thanks for the process. So.
Any questions for Mr. Withers? No. Okay. We will hear next from Alex Gonzalez. You have 5 minutes. Oh, you wrote. Okay, sorry. It says 5. 3 minutes. My apologies.
Oh, I'd just like to testify as a witness to Mr. Withers living at the property in question.
Wait, sorry. Who is this?
I'm Alex Gonzalez.
Is this in the record, or are we considering facts outside of the record at this point? Okay. Can we? Yeah, I don't see. Not that we can't take a witness, but could we swear him in, please, if he's going to give new testimony? Thank you.
Do I raise my right hand? Okay.
Do you swear or affirm that the testimony that you are about to give in this proceeding shall be the truth and the whole truth?
Yes. So help me God. So I'm here to testify that he was living at the property in question for over 1.5 years. And this is just a little bit of the evidence that he presented. And he had to wear, like the gentleman said, he had to wear a criminal ankle bracelet for the time around his ankle just to prove that he's sleeping there every night. So I hope that you can rule in his favor. I'm not sure if this is a court or what is this, but just rule in his favor, because I can testify that he's been living there for over 1.5 years. And that's all I have to say. So thank you very much for your time.
Can I ask you a question?
Yeah.
Who exactly are you vis-a-vis Mr. Withers?
I'm his friend. I go visit him all the time in Santa Monica because I live inland and I love Santa Monica. So that's why I'm always over at his house. And he's always there. I've done slumber parties at his house with my friend Emily. Go ahead. Yeah. And we just have a fun time and everything, because Santa Monica is an awesome place to live. It is, yeah. And I'm here just to testify that I even sleep at his house because I like it so much. So, sorry. It's okay.
We have another question.
Okay.
So just because we are taking testimony from you, we just need to establish, and I think it's pretty clear from the record, but like what your foundation, what your personal knowledge is. So your personal knowledge is that you're a friend, mm-hmm. and that you occasionally stay with him. About how often do you stay with him per week?
2 or 3 times I go and visit. I don't always spend the night because I have to work the next day, and sometimes I have to work way out somewhere else. So. But I visit at least 3 times a week. Okay. I'm always over there because we go to the Whole Foods together there in Venice. Okay. Right on Lincoln and Rose. That Whole Foods is amazing.
So just only because I look like. We might as well, if it's in the record, we might as well get it clear.
Right.
So you visit him every week, 2 to 3 times a week.
Yeah, unless I'm out of town.
I'm not disbelieving it. I just want to really, really clear. We can go through this, yes or no. So you visit him 2 to 3 times a week, every single week.
Unless I'm out of town. Sometimes I have to go to, like last week I was in Salt Lake City. But we always do stuff together. Everybody thinks we're gay, but we're not gay at all.
Okay.
We just like each other a lot.
Okay, I don't think
So-
that's relevant.
But so 2 to 3 times a week, every week for the last year and a half?
Yes, all the time.
Okay, and about how much time do you spend with him? Like during the day? How many hours per visit?
Maybe an hour and a half to 2 hours sometimes.
Okay, and it's always at his house, or is it just like out and about in Santa Monica?
It's at it. We usually meet at his house, then we go out and about and do stuff.
Okay, and I'm not like, look, there's obviously a high quantum of evidence that has been submitted.
Oh, this
I
is
think
just a
it's,
little bit of
you know,
it. Look
like,
how crazy this is.
Well, I mean, look, like clearly Mr. Withers took the direction of the board, went above and beyond, and really wanted to make sure that there was no possibility that, you know, there could be rebuttal evidence. So I totally appreciate that. You know, I wouldn't necessarily say that's like the standard that we hold everyone to, but I 100% appreciate and acknowledge the effort, and I appreciate.
No, we're not. Are there
testimony.
additional questions?
So, but that was all I wanted to clarify.
Okay, thank you.
I have a question for Mr. Withers, actually. Yeah. That's fine. When was the last time that you Airbnb'd your apartment or unit?
I did a couple like early September of 2018.
Okay. Are you represented by Rosario Perry in this matter?
Yes.
Okay.
Yeah.
Do you have questions? Okay, that's it. Does not appear as though we have further testimony on this item. So we will move, unless I'm missing anyone. No, we'll move to discussion. We have Commissioner Foster up first.
Thank you. I want to start with a question for staff. So we had a case last year, and now we have a similar case under similar circumstances, where someone's, using these newer methods to offer their own generated evidence. So I just want to ask you, I'm no Luddite. I get it. We're going to evolve in our investigative techniques and evidentiary techniques, and will evolve. But what weight are we to give this, and what do the courts say about self-generated, supposedly time-stamped? I mean, it seems like a pretty light load a heavy load to be able to prove beyond a doubt that these, I don't mean this case, but I mean any case, that these things aren't tampered with or created. I mean, I can send tiger text to somebody in Maxine Waters' name if I want to. So I like to rely on our tried and true methods, for ascertaining these occupancies. And I don't mean this case. I have not yet offered my opinion in this discussion of this case. But I wanted to ask you before we start, could you please frame for us how you would like us to treat, and legally how we should treat in this quasi-judiciary capacity, evidence like this that is self-created?
Well, first, the standard that the board is required to determine that a party meets is not beyond a doubt or beyond a reasonable doubt, but preponderance of the evidence. And in reaching that determination, the board is not bound by the rules of evidence that would apply in court, but rather may consider any evidence that a reasonable person would view as probative of a serious matter. So there is no real bright line rule that we can apply. The question is just, does the evidence preponderate in one direction or another? And is the evidence that is purporting to do that the sort of thing that a person would rely upon in the conduct of serious affairs? In this case, for example, and I'm not sure if it was in another case or not yet, the party was using not a self-generated piece of evidence only, but also something generated by a third party. Mm-hmm. And there's no reason to think that the person here has the ability to influence or control what that third party does. That would seem to be the sort of evidence that a person would reasonably rely upon in the conduct of serious business. Is that responsive to your question?
It is,
Okay.
completely. So I'm ready to, with that framework, I just wanted, we keep seeing this, so I wanted to sort of get this for myself and for the benefit of the public who may be watching, and for the appellant, or for the petitioner. The last case has no bearing on what we do now. It's this case, and I think you've proven, that you live there finally. It doesn't mean that your tenant, Mr. Ross, is right or wrong. It doesn't mean, but to my opinion, you've satisfied our requirements, and that's it. I think it's as simple as that. Thank you very much.
Commissioner Phyllis.
Thanks. So I really appreciate Commissioner Foster's discussion to like what type of evidence do we consider reliable and what are our guiding standards, because we're seeing more and more situations where we're talking about people looking at metadata, we're talking about people doing timestamps, what should be our governing principles in terms of, whether this is credible or not, how do we make credibility assessments, even though it's absolutely true that the board is bound or not bound by the rules of evidence. I think generally speaking, the rules of evidence provide a good guidepost for what's credible and what's not. So something that's contemporaneously recorded, like metadata that shows no evidence of tampering, to me that's more persuasive than a post hoc, hearsay stamp on an image that purports to say this is when it was taken. So, all of that said, I recognize that Mr. Withers has gone kind of above and beyond in terms of what we generally require. I want to also make it really clear to the public that we don't require ankle monitoring bracelets. Like that is, I appreciate and understand why Mr. Withers felt it, was necessary because he didn't want to miss again. I totally understand and, I don't fault you at all for wanting to really prove this. But, hopefully we can find some sort of clearly established standard where folks don't find our process so onerous and feel like they have to wear these types of devices to prove it. Also because I'm not sure, given that this is an ankle monitoring device and ankle monitoring devices can be, unless it's literally put on by law enforcement or someone with a contract, can be removed. Like, I want to just be very clear how our applicants can follow, pretty baseline level standards that aren't prohibitively expensive. I'm sure it was an expensive thing to do ankle monitoring. I don't want that to be the case either. So as long as we're communicating clearly on what those standards are, I'm happy, that to grant these petitions. We have no discretion not to. We have to under the charter. So, this case clearly meets what I'm comfortable with in terms of granting the petition. And I hope on a going forward basis, we really are mindful about what we're asking of our petitioners.
Commissioner Duran.
Wow. So Commissioner Phyllis and I are completely 100% simpatico on this. I wanted to just highlight the fact that for everybody else out there that while it's clear Mr. Withers wanted to get this done and not have to try again or anything like that, and he did those extraordinary efforts. That is not what's required, and as Commissioner Phyllis eloquently stated, it's pretty clear what the standard is for people who may not have the ability to get an ankle bracelet. And it's also interesting, and important to note the point about how those can be taken off unless they are placed on by a police officer. So that point's well taken as well. But in any event, I'm satisfied based on the preponderance of the evidence, which is our standard here, that he meets the requirements he needs to meet to get this granted.
Okay, Commissioner Foster. I have a quick question for staff. I know you don't have the data at your fingertips, but overall, in recent years, what percentage of owner occupancy exemptions would you say come that we grant and that are relatively straightforward?
I would say over 90.
Okay, thank you.
Yeah, I mean, my thoughts. I would have to say that this is a preponderance of the evidence, no doubt. Of course, I wonder why this seems to be an almost exaggerated attempt at this point. I know that we advised him to come back with additional evidence. This is that and more, but I am concerned that if we start accepting these forms of evidence, not being a court of law, not subjecting the evidence entered into the record to, like chain of custody requirements, to, if we're really going to accept ankle monitoring evidence, why, we have no way of knowing that it wasn't a dog that was wearing this ankle monitor, et cetera, et cetera. I just want to be very clear of what, good evidence for us to consider absent, a legal proceeding where we're entering evidence into the record in front of a judge. What evidence is considered dispositive here? I think in this circumstance, there's quite a wealth of information. I'm just a little bit concerned about what this decision means for setting a precedent for future cases. So that's all I would say. Commissioner Duran, another comment?
I forgot to take my thing off. Think about sure. If everybody's ready, I would move that we grant this petition and the blah 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 facts. And,
You were so close.
I know. I almost got it.
Excuse me.
Help me out with the.
Yeah.
Adopt the findings of fact and conclusions of law.
Commissioner Phillips, did you want to say something?
Yeah, I just wanted to clarify what evidence I thought was persuasive here. And it's not like the ankle monitoring or the timestamps. It's the fact that they have a homeowner's exemption, that they have utility usage, that they have, their license and voter registration is all the standard things.
Right.
I appreciate the selfies. I think that would be a lot of work well, I mean,
okay,
I acknowledge that would be a lot of work to fabricate, so that does have some persuasive value. But just on so people generally know on a going forward basis what the commissioners have found persuasive. That's what moved me.
Thank you for that clarification. That was helpful. Okay, I think we have a motion on the floor to accept the findings of fact and conclusions of law. Is there a second?
Second.
Okay, a second. We'll call the roll.
Commissioner Sultan.
Yes.
Commissioner Phyllis.
Yes.
Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
And Commissioner Trosis.
Yes.
Motion carries.
Thank you. Okay. Moving on to 10A2, 1790, 1402 Maple Street. Does anyone need a staff report?
I would move to grant this exemption.
Second.
Okay. Can we get a vote?
Yep. Commissioner Phyllis.
Yes.
Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
Commissioner Sultan.
Yes.
And Commissioner Trosis.
Yes.
Motion carries.
Thank you. All right. Item 11A, a public hearing on a potential new regulation 4203. Can we have a report from our esteemed counsel?
Yes. I assume that I am the esteemed
That would be
one.
you, because Haka is walking out. Okay.
At this public hearing, the board will consider whether to adopt a new regulation under which a rent decrease due to the reduction of housing services or maintenance would be calculated from the date when the petition was filed. The board will also consider whether to repeal or amend a regulatory provision that requires the board to dismiss a rent decrease petition if all issues have been resolved as of the hearing date. The voters created the rent control law to ensure that rents are not increased unreasonably and to ensure that landlords receive rents that are sufficient, but no more than sufficient, to achieve a fair return. The board exists to administer the rent control law and to adjust rents as necessary to achieve the law's overall purpose of ensuring that rents do not become unfair. It does this in part by adjusting rents downward if there are reductions in services or maintenance by an amount commensurate with the value of those reductions. Under the board's existing practice, such rent decreases go into effect on the first rent due date occurring 30 days after the decrease decision is issued and account only for reductions in services or maintenance continuing from that date forward. As members of the public and the commissioners and commissioners have observed, this practice has the result that tenants who have been paying a rent that has been proven unfair for what may have been several months have no remedy. Thus, the board has concluded the existing practice is inconsistent with the Charter's purpose. To address this problem, the board last month directed staff to draft a regulation under which rent decreases, while still going into effect only prospectively, are calculated to account for periods of unfair rent paid by the tenant before the date of the effective date. To ensure that the calculation isn't needlessly cumbersome and that all parties are granted maximum due process, the board has directed that the regulation provide for the calculation of a decrease only from the date when the decrease petition was filed with the board. The proposed regulation 4203, included in the body of the staff report for this public hearing, accomplishes that result. At the board's last meeting, a member of the public asserted that calculating rent decreases to account for reductions in maintenance or services occurring before the decrease goes into effect would be illegal under 2 Court of Appeal opinions. As discussed in greater length in the written staff report, that assertion was incorrect. 2 separate published appellate opinions, one addressing a regulation of this board that is substantially identical to the regulation proposed here, the Court of Appeal has upheld this type of rent control regulation. In addition to the proposed new regulation 4203, the board last month asked for an analysis of the pros and cons of amending or repealing existing regulation 4004 subdivision A. Under that subdivision, if at any time before the hearing an owner responds to a tenant's rent decrease petition by asserting that all problems complained of in the petition have been fixed, and if the board determines that the landlord's claim is true, the board must dismiss the tenant's petition. This arguably runs counter to the policy that the board's proposed regulation 4203 would advance. As noted above, the proposed regulation would provide a remedy covering more of the period during which unfair rent was paid from the date when a decrease petition was filed. If the petition were dismissed even when the tenant had paid rent that had become unfair due to the reduction of services or maintenance continuing after the petition was filed, merely because the landlord had belatedly, but before the hearing, corrected problems on which the decrease was based, the tenant's remedy for payment of unfair rent would be eliminated. There may be valid policy reasons for accepting this result. As noted at its March meeting, the board has pursued a policy of promoting and encouraging compliance with the law first and focusing on remedial measures only when those efforts fail. This is why, for example, a tenant may not file a rent decrease petition until he or she has first notified the landlord of an alleged problem in writing and given the landlord an opportunity to fix it. There may be value in giving landlords one last incentive to correct problems before a tenant's rent decrease petition is heard. But if the board were continued to provide this incentive, it may wish to limit the period during which it is available. If a landlord may obtain dismissal of a tenant's rent decrease petition at any time before that petition may be heard, he or she may feel incentivized to delay the hearing for as long as possible. This would require the tenant to live with a reduction in maintenance or services and with payment of rent that has become unfair as a result of that reduction for an extended period. To prevent this, the board could amend Regulation 4004 Subdivision A to say that the board must dismiss a tenant's rent decrease petition upon proof that the landlord has corrected the problems on which it is based, but only if that proof is given before the first date on which the hearing is originally scheduled to be held. The proposed statutory language that will accomplish that is also included in the body of the staff report. Alternatively, the board could simply repeal Subdivision A. Thank you.
Thank you, Mr. Lewis. We have a few public comments on this item. I'll first call up E. Ruby Gonzalez. And then after that will be J.L. Jacobson.
Good evening.
Sorry, you have 5 minutes. 5 minutes, yeah.
My name is Ruby Gonzalez, and I have resided in Santa Monica for the past 32 years. At a recent action meeting, I heard that the Santa Monica Rent Control Board was considering a proposal that would grant rent decreases starting from the date a petition was filed, as opposed to the date when a Rent Control Board decision is rendered. This brought back memories of a nightmare I went through myself about 5 years ago, and I felt compelled to come and speak. This process is already bad and unfair towards the landlord, so please do not make it any worse. In my case, some of the items that my tenant pursued a rent reduction for were missing window screens, damaged floor coverings, termites in the garage, and reduction of laundry facilities. Fortunately, the hearing examiner realized that almost all older buildings in California have termites, so no rent decreases were granted for those issues. Although the apartment where the tenant lived had beautiful exposed wooden floors, they had not been polished for some time. I would have done the work, but the tenant wanted me to remove all her furniture and put it back, and I was afraid that if something were to break, she would have another complaint or would pursue legal action against me for the damages. So I neglected to complete this work, and the Rent Control Board ruled in her favor, granting her an $80 monthly reduction in rent. The decreased decision granted an additional reduction of $80 per month based on loss of laundry facilities. This was incorrect because the decision correctly states that the tenant provided her own washer and dryer inside her apartment at the beginning of the tenancy. The tenant also caused the loss of housing services by complaining to code compliance that the laundry machines had been installed without proper permits. She caused her own injury and then wanted me to rectify it. The tenant then aggravated her injury by claiming that it cost her between $28 and $78 per week to do laundry. These claims were absolutely absurd. There is a laundromat located approximately 100 yards from the property. I used to live in the same apartment that the tenant did, and the machines at the laundromat were not that expensive. She lied, and she said she did 5 loads of wash, which were ridiculous. She was a single older woman, and I was a mother of 2 small children, and I rarely did so much laundry. The decision was also unreasonable and unfair because I was required to install laundry machines that were free of charge and not coin operated, even though the washer was coin operated when she first began using it. Therefore, I would have had to provide free laundry to everyone on the property if I complied with the decision. The saddest part of my story is that the tenant was my sister. She had lived on the property without a rent increase for 12 years due to the kindness of me and our parents, who were the owners of the building. Our brother installed the laundry facilities in the first place when I lived in that apartment with a different sister who was not so evil. In 2012, I became 100% owner after taking on $1 million debt to pay off the rest of my family members. She inherited a single-family home, free and clear, in South Pasadena, which she rented while she was my tenant. I needed to increase her rent, and she retaliated in any way she could by filing code compliance complaints and outrageous claims with the city manager's office. It was a horrible ordeal that took away time from my children, my work, and filled my life with stress. I'd also like to state that during the 12 years that she lived there, she never raised any complaints to any family members about any issues with habitability. In summary, I think that the rent control law should be changed so that at least one commissioner who has been subject to radical rent control. You don't need to make the situation any worse. It's already bad enough. Thank you.
Okay, thank you, Ms. Gonzalez, for coming. J.L. Jacobson, you also have 5 minutes.
Didn't work either. There's no clock on, so I don't know when I'm. J.L. Jacobson, 2812 Santa Monica Boulevard. I move all over Santa Monica Boulevard. Tonight, 40 years and a day after the rent control law was adopted, the board here proposes to amend the charter amendment so that it can make monetary damage awards based upon a date when a tenant files a rent decrease petition, not when the decision is rendered. I don't know the good reason for this. According to the general report summary at the Rent Board's website, quote, the number of petitions filed in 2018 by tenants claiming landlords had removed amenities or reduced services was the highest in 10 years, 97 petitions. So you're doing a booming business in rent decrease decisions already. I don't know how you could get more unless you had Vanna White up there spinning the wheel of fortune and giving out the awards. $20 for carpeting, $15 for dirty laundry room, $200 for parking spaces. Now, the staff report says that the awards begin to run from the date the tenants file a petition, but if you look at the proposed regulation, it doesn't say that. It says, and I'm going to skip some words in the middle, a rent decrease resulting from a reduction in housing services or maintenance will account for the past, present, and continuing reductions on which the decrease is based. Doesn't really say it starts when the petition is filed. Now, when I was here last time, I quoted 3 sentences from Sterling versus Santa Monica Rent Control Board. 1, contrary to the view of the Superior Court, there is not any question the instant manner of an unconstitutional exercise of judicial power or the awarding of damages. 2, in all cases, respondents' determinations are prospective in nature. And 3, tenants are not authorized to withhold rent as compensation for the landlord's failures. Respondent's hearing examiner makes a factual determination on the evidence for the appropriate maximum allowable rent to be charged in the future only. Now, it's good that people can look at city TV and see, these proceedings and what was said, because you never know that from the staff report. The staff report goes and says under the heading, is this legal? It says, first, the speaker, that's me, asserted that including the value of a past loss or services of maintenance in a prospective decrease petition would be an award of damages and therefore would be an illegal exercise of judicial powers. In support of that assertion, he quoted the following sentence from that opinion. In other words, he quotes the first sentence and not the following 2. Contrary to the view, and so he quotes the first sentence. He says, from this sentence, the one sentence that's quoted, the speaker extracted the idea that if the rent decrease awarded in the case had accounted not only for reductions in services, but also accounted for reductions that had occurred before that date, which it did not, it would have been an illegal exercise of powers reserved only of the courts. But this is a serious misreading of the case. Well, actually, there's a very serious misleading of what I said and what the Sterling decision said. And then it says, the Sterling court opined that no damage has actually been awarded by the Rent Control Board in that case. It did not opine, even in dicta, much less as a holding, that a rent increase going into effect prospectively would have been awarded of damages. It did not say such an award, if it had occurred, had been illegal. Well, actually, it stopped up all the rent decreases in Santa Monica, not just the ones for that case, because you were exercising judicial powers. Now, it's true that they didn't opine anything about past reductions because there is nothing about past reductions in Section 1805. That idea didn't come up until you guys came up with it quite recently. And then the analysis continues from the staff report. Even if the Court of Appeal had said these things in the 85 opinion, it would be of no significance now. It rejected the idea that administrative agencies, and this board in particular, can never award damages in McHugh versus Santa Monica Rent Control Board. There's no dispute that you can award restitution type damages in excess rent cases. The issue here is, why are you doing it in the rent adjustment process? 2 completely different issues. Now, by quoting Larson versus Superior Court, a 2011 decision, I like that as a good example because it quotes both McHugh and Walnut Manor, which is in your thing. So your staff report just makes a sentence and cites the case, and if you look at the case, it doesn't say that at all. Now, in Larson, it pointed out, in McHugh, is that my time over?
Thank you, Mr. Jacobson.
Oh, I had so much more.
Thank you for your analysis. Lori Brown, you are next, and you also have 5 minutes.
Good evening. I'm here tonight to speak for 5 minutes as per your request for public input onto whether you should adopt a new resolution regarding 4203 and 4004. For the record, my name is Lori Brown, and I ran for a seat on the Rent Control Board in the last election. I ran because I believe there should be at least one commissioner on this board that is interested in complying with the requirements of the law instead of attempting to expand its power at every opportunity. I've watched for the past 5 years as you have not asked one question of those who bring a different point of view to the dais. Not one. It has appeared to me and to many that this current board is not interested in the experience and knowledge that our very own housing providers have brought to this room and demonstrated in last week's Rent Control Board meeting. For example, not one question was asked of Mr. Jacobson, who's been involved in our city housing crisis, which has been affordability, availability, and accessibility for the past 40 years. Sorry to date you, Mr. Jacobson. So tonight I've come here with the hope, as one can only continue to live with, and hope that one day all voices will be heard. Perhaps it will be tonight. I would like to refer to the staff report for these proposed regulations states the following at page 2, second full paragraph under the heading. Quote, why is the board considering this and what is the staff proposing? The voters created the rent control law in Santa Monica to ensure that rents are not increased unreasonably and to ensure that landlords receive rents that are sufficient but to no more sufficient to achieve a fair return. The voters created a board to administer the rent control law and to adjust rents as necessary to achieve the law's overall purpose of ensuring the rents do not become unfair. The board does this in part by adjusting rents downward if there are reductions in services or maintenance by an amount commensurate with the values of those reductions. Under the board's existing practice, such rent decreases go into effect on the first rent due date according to at least 30 days after the decrease decision is issued and account for reductions in services or maintenance continuing from that date forward. As members of the public and commissions have observed, this practice has the result that the tenants who have been paying a rent that has been proven unfair for what have been several months have no remedy. Thus, the board has concluded the existing practice is inconsistent with the charter's purpose. The statement just quoted raises 2 questions in my mind. 1, why have tenants been paying a rent that has been proven unfair for what have been several months? And 2, why don't they have a remedy? From what I've seen, the board seems to pay no attention to the requirements of the rent control law, which was required that it issue prompt and timely decisions. I found this was a major point of discussion in the published decision of Santa Monica Properties versus Santa Monica Rent Control Board. After taking more than a year to issue a final decision, the Santa Monica Rent Control Board decreased 2 tenants' rents because their landlord, Santa Monica Properties, lowered the temperature on a hot tub during workday hours, heating it only during the evening hours, and altered a sauna's timer knob so that the sauna heated for 1/2 hour as a turn instead of the previous 1 hour. SMP filed a petition for writ of administrative mandate challenging the rent decrease decision. In the same pleading, SMP brought a petition for writ. Where's my time? I'm not going to be able to get to all of that. So the decision then says on page 755, the reinstatement of rents, Santa Monica intends, I can go through it, but I don't think I'm going to get to it. But I don't even know that you listen to half this stuff. But I'm going to go back to that they found that decreases in rents ordered by the hearing examiner decision should be retroactively paid to SMP. No rent decreases should have been ordered on the evidence presented at the administrative hearing in the case, which states the following. The time for decision, the rules and regulations adopted by the board provide for final action of any individual rent adjustment petition within 120 days following the date of the filing of the individual rent adjustment. When you take so long to take the final action, the rent decrease cases, then the tenants suffer actual hardship when they're required to pay back the rent, which was withheld when the decision got reversed. This board seems to be acting as the most reversed rent control agency in the state of California. The subject of court actions where your decisions get reversed are discussed regularly at the Action Apartment Association meetings. At the last Rent Control Board meeting, the staff was asked how long it takes to render decisions in rent decrease cases. It could not give a definitive answer. The staff should have known because the following regulations were identified at the end of the Santa Monica Properties decision. Regulation 4007 provides as soon as the practicable, and I'm not going to be able to get to all my time, so I'm going to just say to the end,
I find it fascinating that board's administration and legal staff were completely unaware of these regulations adopted by the board many years ago. For the reasons stated, if this board complied with the requirements of the rent control law and its own regulations, there would be no need to worry about tenants paying unfair rents for long periods of time. Now, sadly, unless you want to ask me, I can give you the ones in between of all the case law that I stated. I doubt that's going to happen tonight. But since I do have no minutes left.
Ms. Brown, would you please give us the rest of your statement? I'd like to hear it.
Okay, thank you. Let me ask you a question. Do you want to hear the case laws, or do you want to hear the rest of my statement? So
I'm happy for you to tell us anything that you'd like to tell us to finish what your thoughts here.
Well, I'd like to be able to understand that what I've said as far as if I could read the regulations,
sure.
Because I felt like I couldn't get it. So I think I stopped it as the voters created the board to administer the rent control law to adjust rents as necessary. Oh, I think I did that. Account for only. And thank you for your patience. Going back to the reinstatement of rents, which was on page 755. The SMPD contends that the Rent Control Board hearing examiner's compliance decision demonstrates a failure to proceed in the manner required. You know what? I'm not going to go back and say that. What I'm going to go back and tell you that I also had the same experience as the previous person that spoke. And at the end of the day, it did not go in the tenant's favor. So it seems to be that 120 days you should be able to file these motions. And one of the things I'm going to ask you here tonight, which is, you made some statements about the ankle bracelet, and that a dog could wear an ankle bracelet. And for anybody watching on television, that is so not true. And I would really advise this commission consider taking an advisory board and take in somebody, a landlord, take in tenants, and one of you, if you'd like, make a subcommittee and actually start thinking and talking about what actions and what people are doing. Because a dog could not put it on. It's a legally binding thing, just like if you were in jail. So I think that the things that come up here are based upon what the previous person said from not experience. And sadly, you can't talk about raising a child unless you have a child. And most parents will tell you that. You could think you know, but I can tell you running a building is very complicated, and the decisions that you make here today have so many consequences, and there's a law in place. Leave the law in place as it is, and then tend to the problems. Daniel Westcott, Mr. Westcott, who had challenges, I get it, he has challenges with his building, but it's not about a rent decrease. As a matter of fact, that rent decrease is not going to help change the situation that he has, and to bring cases without realizing what the effects are, you're losing your units. And I've written down, thank you for the extra time.
Okay, thank you, Ms. Brown. Also, if you have a written statement that you want to give to Mr. Gwynn, we're happy to take it as a public comment. We can also take written statements. So if you prepared that, that's fine.
So in other words, afterwards I can leave it and then you'll get it?
Yeah,
okay,
yeah.
Or I'll send it to him
via
via email.
All of those, we take emails, we take statements here, we'll take anything written
and
as much
really,
as...
I'm pleading for an advisory board for you guys. Pleading. New York City has 2 landlords, 2 homeowners, and 1 tenant. I'm pleading that you do an advisory board before you start taking these actions.
Okay, thank you, Ms. Brown. Thank you for your time. Okay. I just wanted to address a couple of things about to our council about the number of days that it takes for us to hear these petitions. Could you just elaborate as to whether or not there is a legal requirement for us to hear these within a certain number of days?
The charter provides that decisions must be ruled upon finally, including by the board, within 120 days, unless there is a good cause for doing otherwise.
And typically, what have we seen as good cause in some of these circumstances? Or how are we defining good cause? Or is it liberally construed?
Good cause is somewhat liberally construed, but there are things that are clearly good cause. Hospitalization, unforeseen illness, being called up for active military service, car accident.
Okay. And how often is it that you would say, or maybe this is, I don't know, any of you can address this question, that there's a request for some sort of continuance in these cases for some sort of cause? Okay, maybe the better question is around what percentage do you hear within 120 days?
I don't have that information at the top of my head.
Okay. Would you say that more than 25% of the cases get continued for some reason that asserts good cause? If you
I can't.
Okay,
answer.
that's fine. That's fine. I just wanted to know what the roadblocks are. Okay, thank you, Commissioner. Or any questions for any of the speakers? No. Okay, Commissioner Foster.
Thanks. You took all my questions.
Sorry, no, sorry.
No, we just had similar questions. The only question, keeping it's our responsibility to stay within the narrow confines of our agendized items. Whether we would like to talk about other things at other times or not, sometimes we can't, and it's important for the public to understand that we can't always answer public comments or answer speakers or answer emails. That's not how our process works when you're serving on an elected body. And so sometimes when we'd like to answer, it's not appropriate to do so. But having said that, so on the agenda, we are simply considering the public's comments and our own feelings on this regulatory language. And I, for one, have been thinking about this like others have for quite some time, and it seems to be completely equitable to, if and only if and when it is proven that somebody has been paying rent for something they were not receiving, it makes complete and total logical mathematical sense that when the hearing or when the petition was brought formally and legally, that the clock starts. And really the clock started 30 to 60 days before that, because there was written notice to a landlord. The landlord has presumably opportunity to come check it out, and then presumably even more time before a hearing starts. There's a lot of opportunity there to investigate, and there can be honest differences of opinion between a landlord and a tenant as to whether something needs to be fixed or not, or whether something's broken or not, or whose responsibility it is. There can be honest disputes, and there can be reasonable continuances, but my only question tonight was going to be, I am completely happy with the language as it stands. And my only question was going to be concrete examples of what constitutes good cause for continuances. A trip to the lake cabin is different from a death in the family, or the birth of a child, or a natural disaster. So I just was looking for some clarification for myself and for the public, and for people who have a stake in this, the tenants and landlords of Santa Monica and the community of Santa Monica that wants safe buildings and full tenancies, to have an example of what would be excused absences or continuances in this process. And I'm satisfied that you've answered what those examples are, and I'm ready to move ahead on this and hear from the other commissioners.
Great, thank you. I believe I'm next, but I'll let Commissioner Phyllis speak next. Go ahead.
So I just have kind of 4 brief points. One, I want to make a clarification that this is not an amendment to the charter. I believe Mr. Jacobson stated in his testimony that we seek to amend the charter. Obviously, we can't do that without a public vote. We're enacting regulations that are well within our discretion under the powers afforded to the board under the charter, in compliance with those powers and restrictions. So I want to make that really clear. I also think that it's important to address this concept that there's some sort of distinction between excess rent and restitutionary damages in that context, and rent adjustments here. In both cases, there is excess rent being charged. In one case, it's because a landlord is charging above the MAR. In another, it's because a landlord is presumably charging the MAR but depriving a tenant of housing services. But in both cases, there is a fundamental overage for what the tenant bargained for. And so I think it's really important that we're clear that that distinction is in my mind a logical fallacy. I also want to be clear that I think this is really important because we already afford retroactive benefits to property owners. When a rent decrease petition is cured within a certain amount of time, our charter requires us to afford retroactive benefits to property owners. Essentially, what I've heard folks ask for here is that that we preserve a kind of anomaly in our regulations that essentially deprive tenants of any remedy for any relief whatsoever. I mean, look, like, I'm all for fairness. I'm all for providing people the maximum relief under the law. But when you are literally asking to deprive a tenant of any remedy at all, I mean, it's not persuasive. It's not compelling to me. So, I think that it's important to be on the same page there. And then lastly, I would like to respond to the intimations that we aren't hearing cases on a timely basis, whether it's rent decrease petitions, whether it's excess rent petitions. At least as far as I've seen staff pay enormous attention and always advise us when we're potentially running afoul of a timely adjudication. I would like more information on that to confirm it, because I would like more, than just anecdotal knowledge. I think it would be helpful to respond to the public inquiry. So that's my one piece of direction for staff, but I support the regulations as drafted.
Okay, do any of the other commissioners have a comment before I say something? Or do you want to say something? Okay, I appreciate everyone coming here tonight. I appreciate the consideration of the multiple options that we heard last time, and then us deciding that this was the direction we wanted to go forward with some draft language. This is something we've now looked at for the last 2 months, and I wouldn't say that I've heard anything or had any meetings with individuals that have been that have persuaded me away from my stance on this last month. I think we need something that's in the middle, right? So initially, when I came to the first meeting and asked for us to agendize this, I was asking for us to put it, to write a regulation that was retroactive to the date that the harm occurred. I now realize, after hearing from landlords and considering this issue, that is not necessarily the most equitable approach. Although we might be able to remedy everything up until the date that the harm occurred, there could be issues where a tenant would take advantage of that there would not be a circumstance in which a landlord and a tenant could have a discussion and try to remedy it amongst themselves before filing with the board. And I also think this is a little bit cleaner. But as staff brings up in the staff report, what happens when you have a tenant who might be taking advantage of the process, just like a landlord would, to delay the process. So I really appreciate the addition of 4203A3, that if any portion of the hearing process is delayed or continued for good cause, the calculation of the total decrease amount for past reduction shall not include that period of delay or continuance. I think that addresses the issue of anyone trying to take advantage of this process of potentially drawing out the amount of time that it takes to hear these cases. I, like Commissioner Phyllis, wonder. We hear from these landlords, but then at the end of the day, we have to ask ourselves, what is so unfair about this process as currently construed to the landlord, right? If anything, in my mind, you give the tenant no remedy for the 3 months, 4 months, 5 months, 6 months, however long it takes, even if it's 2 months, until a decision is made, and then the next month's rent goes into effect. And I think that is not equitable. It's not enforcing the charter in the way that it was intended. And like Nicole or Commissioner Phyllis mentioned, it seems to be this one anomaly now that we haven't taken care of. So I don't really feel that there is a remedy for tenants currently. There's been a removal of amenities, and they're not provided all of the amenities entitled to them under their contract for a significant period of time. And I am always concerned that just like you have bad actors who are landlords, you have bad actors who are tenants, and we don't want any tenants taking advantage of this new change. And I think that I'm satisfied that this is being addressed here. So I'm prepared to move forward. I'm also satisfied that, we have some answers on what good cause means, and of course, we always want to try to expedite this process where possible. It appears as though Commissioner Duran wanted to make a comment.
Yeah, just briefly. I wanted to say that at our last meeting, I thought we had a good debate on the issues, ramifications, and I'm satisfied, based on this iteration, that it's addressed those issues and is consistent with what my understanding was. I feel content to move forward with this proposal.
Thank you, Commissioner Foster.
I forgot to ask staff one last question. It's just about the tail end of your recommendation. You give us an alternative, so we need to clarify. And none of us have mentioned that out loud yet, so I just wanted to say that, honestly, if you feel that they both achieved the same end, would you say it was simpler and cleaner to repeal it, or is it simpler and cleaner to include it with the amended language? I'm okay either way, but I'd like to know which is simplest.
I believe that they're equally simple. One just does more of the same thing than the other one does.
We've had troubles in other areas where things aren't explicitly stated. So sometimes when things are not explicitly stated, they're left up to interpretation. So perhaps we should leave it in and explicitly state it as you've done in alternative A. The corrected language. So I would move that we pass this regulation and that we take staff's report on its face and choose the first option of amending the language in the last part at Part A.
Okay, thank you. I also neglected to address that, and I was thinking it right as you were saying it. I think it's better to be explicit. If Mr. Lewis thinks that this cleans up some items and just makes it very explicit, I'd rather do that than repeal it. I think I was in favor of repealing last time, but I'm okay to keep A in its new iteration. I am also satisfied with our draft of 4203A, B and C. So
is that a second? Or?
Yeah, with that. Sorry. Yes, I second.
Switch.
Yeah, I second what your original motion was, and I believe. Yeah, that's consistent with the recommendation. We're just voting to amend Regulation 4002. So I think with that we can take a vote.
Commissioner Duran.
Oh.
Just to clarify, it's 4004. I may
Sorry,
have had a
I read this thing here. You're right. It does say it for. Okay, thank you. 4004. Thank you. You're right.
Oh. Now we'll go. Commissioner Duran.
Yes.
Commissioner Phyllis.
Yes.
Commissioner Sultan. Commissioner Foster?
Yes.
And Commissioner Trosis?
Yes.
Motion carries.
Okay. With that, we are at the end of our agenda, and we have no further comments. But when we move to adjourn today, I move that we adjourn in the memory of Beth Lederpack. Oh my God, this is going to be difficult. Beth was a loving member of the rent control family for over 20 years here in Santa Monica, and she passed away on March 30th. And I want to honor her memory. She was a Santa Monica community leader and worked for the city of Santa Monica for over 25 years. Beth earned her bachelor's degree from Cornell, her master's degree in regional planning from the University of Pennsylvania. And while she began her career working in Philadelphia, she made her way to the West Coast and then settled in Santa Monica. Beth has made her mark on this community as a galvanizing and dynamic force in social justice, political and community organizations, including Santa Monica for Renters' Rights, the Women's International League for Peace and Freedom, the Santa Monica Democratic Club, and she was a founding member of Santa Monicans Allied for Responsible Tourism. But Beth's activism didn't just stop there. She was at the forefront of the local living wage movement, so important to many of us, fighting for the rights of low-wage workers. She was a longtime affordable housing activist, having served as vice chair on the board of directors of the Community Corporation of Santa Monica for over 10 years, as vice chair of the Ocean Park Community Organization, and as a member of the City of Santa Monica Housing Commission. Beth also advocated for the welfare of her coworkers as a union leader for Santa Monica Rent Control Board and the National Organization of Legal Service Workers Local 2320. For her exemplary record of civic leadership, Beth received the Communitas Award in 2001 from the Church in Ocean Park, and she also received a commendation from the California State Legislature and the City of Santa Monica. She was on the board of directors of the Church in Ocean Park, and she also served on the board of directors for the Growing Place, a preschool she valued for its commitment to providing quality all-day, year-round early education for the city, for the children in the city of Santa Monica, our workers and other working parents. Beth loved and appreciated the performing arts, especially music and theater, and she was an avid supporter of the Santa Monica Public Schools choir and theater programs, in which her daughter and so many other students have thrived. And I just wanted to say, we know that Beth was a very, very loving mother. All of us are thinking about her family, and especially about Anna during this time. I think Beth will be remembered very much for, her honesty, how forthright she was in all of the advice that she gave, how lovingly and helpfully she served all of our landlords and tenants in the city of Santa Monica. She was always ready to laugh and give advice, and there's no one more generous than her with her time and resources, and obviously I think that manifested in her later years. Now she had very much cared for shelter animals, bringing them into her home as well. And I just couldn't say enough about what a vital member of this community she was, this family that she was. And I think that we're all going to miss her in her presence here very much. So I wanted to adjourn in her memory. Is there a second?
Very well put. Second.
Okay. I think all those in favor.
Aye.
All right. Thank you.
Mr. Beth.
No, I don't like.